Oh my goodness. We are going to court for the 2-day hearing in the Kouri Richins case. It's Tuesday, it's January 7th, it's 2026. If you are unfamiliar with Kouri Richins, you might remember this case from a number of years ago. She was arrested about a year after the murder of her husband. It took them that long to charge her. She is finally getting ready to go to trial. She was arrested in May of 2023. It starts jury selection in February. There are quite a lot of pretrial motions that need to be done. The court has set aside 2 full days. So we're going to go to Utah with Judge M and his voice, beard, and competence. And we're going to enjoy, hopefully, court just being normal.
I have looked at Mr. Throckmorton's report from June of 2023 and his amendment in March of 2025.
I'm delighted by the name.
With him from other cases in terms of his background and his method. Tell me what you see as the problem.
The court is no stranger to Mr. Throckmorton.
The objections that we have to his testimony, it's basically focused on the first prong of 702, which is whether or not his testimony can be of any assistance to the finder of fact.
Fell right
and
out
the
of my
main
ear.
concern is his conclusions or lack thereof are basically, I looked at this, I cannot say at all whether Kouri Richins signed Eric Richins' name or didn't. I can't say she did. I can't say she didn't.
Right. You skipped a step, though.
Right. Well, I'm getting.
Okay. I mean, he does say with a much higher level of probability that Eric Richins didn't sign it.
Right.
He just can't say that it was with the same level of probability or any, depending on the document, that it was Kouri Richins that.
So as to potential forgeries and as to was Kouri Richins signing Eric Richins' name or did Eric Richins not sign it? And Eric Richins not signing it is something that then the jury can decide, did Kouri do it or did somebody else do it? Because we're not in a fraud trial, right? We're not trying to decide at this point who signed it. The fact that the victim didn't sign it is important. This is going to come up with regard to potentially life insurance policies and loans taken out against the victim's home. The victim and the defendant were married. The victim owned the home prior to the marriage in their own name only. If it relates to the loans taken out, like the HELOCs taken out against the property, Eric not signing those is something the jury's going to want to know.
Made the simulated forgeries.
Right. And the concern that we have is his materials that he provided and that we expect would be laid forward before the jury. Take little pictures of letters and compare them. And, you know, all of us are human and we all have eyeballs, or those of us blessed with the sight have eyeballs that work. And we are tempted to look at those things and compare them and contrast them. And it goes back into a jury room. And the bottom line is they're calling the expert to say, I cannot draw a conclusion that Kouri Richins signed these, signed his name, signed the initials. Even his finding that Eric, I believe the finding he had was a strong probability.
No, what was the finding?
That Eric Richins did not initial the documents, not that he didn't sign the power of attorney, but that he didn't even, a strong probability he may not have initialed them, which is not even to the standard.
Him not signing a power of attorney matters.
Standard of, you know, beyond a reasonable doubt. It's not anything close to that. And the concern that I have is you're taking an expert who is going to basically say, here's all this stuff. I'm going to send this back in the jury room. Y'all can sit there and look at these initials. You can try to figure it out yourself if you think that he did it. But I'm, as an expert, saying I can't say Kouri Richins did.
Main point is there's not an agreement that they have to introduce the power of attorney before we would introduce it. It would be a whole set of facts that might make that come about.
Right.
Is the power of attorney, forgive me, I didn't go back and look, is the power of attorney the basis of one of the forgery charges?
It is not.
Okay. So why would the power of attorney be discussed in your case in chief at all?
Oh, I'm not offering the case in chief.
Okay,
That's
got it.
precisely why.
I see.
It would have to be some facts that arise in the defense case
Got it.
that would implicate
Right, this is for
offering
rebuttal.
that exhibit, and therefore its authenticity would
Okay.
be at issue.
Before the court is the
I like how he
defendant's motion to
clarifies
exclude
what he's
the
ruling
expert
on.
testimony
He makes
of
such a
Matt
good record.
Throckmorton. Mr.
Did you just say Matt? Hey, Matt, what's up?
Throckmorton is offered to testify that the Eric Richins signature on the True Stage insurance application that is the subject of the charged forgery was probably not authored by Eric Richins and appears to be a simulated forgery written by someone who is familiar with or has access to Eric Richins' known signature.
Did the defense say anything about that conclusion? Your Honor, he wasn't able to make conclusions. It sounds like Mr. Throckmorton made a conclusion that it was a simulated signature done by someone who has familiarity with or access to the victim's signature. That's a bit more specific when we are dealing with the wife of the victim. There was new information in there that we had not heard before.
Morton. Mr. Throckmorton is offered to testify that the Eric Richins signature on the True Stage insurance application that is the subject of the charged forgery was probably not authored by Eric Richins and appears to be a simulated forgery written by someone who is familiar with or has access to Eric Richins' known signature. In addition, Mr. Throckmorton has been noticed as someone who may offer testimony in rebuttal or impeachment that there is a strong probability that Eric Richins did not author the ER initials on a power of attorney that the defendant allegedly used to obtain a HELOC on the Richins home, and that there are mere indications that the defendant wrote those initials.
Two
The
different
court
things.
determines under Rule 702A that testimony, which would come in the state's case in chief and perhaps in rebuttal, respectively, is helpful to the trier of fact because it would assist the trier of fact in determining whether the state had met its burden to show that Ms. Richins committed the
Forgery.
charged forgery count regarding the True Stage insurance application. And
This case has both the attempted murder and the murder charge. In addition, there are life insurance fraud charges that are closer in time. The other fraud charges are in a separate case, but the life insurance fraud is closer in time. And so those insurance application forgeries are also part of the case in chief that the jury will decide on. I know we talk about just the attempted murder and the murder the most, but there are other charges here, just not all the charges that originally were here.
may be relevant to show Ms. Richins' conduct related to the HELOC in rebuttal. Moreover, based upon the court's review of Mr. Throckmorton's CV, his education, training, experience, and his substantial history and experience in testifying, certainly in state courts in the state of Utah, the court finds that he is qualified as an expert in the field of handwriting analysis. Regarding defendant's objection to the reliability of Mr. Throckmorton's analysis, the court finds that his analysis and his methodology, and therefore his testimony, are sufficiently reliable under both rules 702 subsections B and C. Ms. Shervanek, is there any admissible evidence of domestic violence by defendant against Eric Richins prior to the allegations related to February 14 of 2022?
I don't believe that would be presented in the state's case in chief.
Okay. Is there any admissible evidence that Eric Richins had any subjective knowledge that defendant attempted to poison him on February 14, 2022?
that he had knowledge of it?
Right.
Yes.
Tell me what admissible evidence there is of that.
I think the court is aware of what the admissible evidence is, the testimony from Josh Kays and Cody Wright, that the
Cody
admissible
Wright's not going to testify, as I understand it, trial, pursuant to.
Did you see Bloodworth's face? That's not what Mr. Bloodworth thinks.
Cody Wright, that the
Cody
admissible
Wright's not going to testify, as I understand it, trial, pursuant to.
That Mr. Bloodworth disagrees.
Not at least regarding the events of February 14, 2022. I don't think he has any admissible testimony regarding that day.
He does. His admissible testimony are his observations, not the content of Eric Richins' conversation, but his observations about
Demeanor?
Eric Richins' demeanor,
You
how
didn't
his
see him. It
voice
was all
sounded.
it was all in the it was all on the phone.
Right,
Yeah,
but
but-
his here.
You can testify to someone's demeanor when talking to them over the phone, especially someone you know well. If they are upset, you know that they were upset.
Hearing observations about his voice, how he seemingly sounded on the phone during those conversations, and not the content that aren't admissible because of hearsay rules, but there are observations that he could make through that phone call.
I wouldn't be surprised if some of those were present sense impressions, but it sounds like they've already handled some of these evidentiary arguments
That is admissible.
outside of our presence.
Currently, the court has not seen in the record a non-speculative basis for the jury to draw an inference that Eric Richins had any subjective knowledge of Ms. Richins' alleged attempt to poison him on February 14, 2022. And in the absence of a non-speculative basis for the jury to draw that inference, that is, that Eric knew that his wife had attempted to hurt him, there's no relevance to Dr. Venino's testimony regarding the dynamics of domestic violence relationships,
Right.
because there would be no foundation for the jury to conclude
For
that
relevance.
the relationship between Kouri Richins and Eric Richins qualifies as a domestic violence relationship.
Obviously, it would be our preference that it all be private and then maybe your ruling could be public. Because your ruling can craft it in such a way that you don't reveal inadmissible evidence. But it seems to me that the danger that a bunch of inadmissible evidence is going to be broadcast.
It's
to
not,
all of our
though.
jury who now have received jury questionnaires and know they're on deck.
Right.
Could be problematic. So we would ask that the hearing be sealed and then maybe just the ruling be made public.
Okay. What's the state's position?
No!
No objection to that, Your Honor.
Ah!
All right.
Nope.
Stop it!
Tomorrow, January 8th, the court has set a hearing to hear oral argument on numerous motions in limine filed by the state and by.
Are you going to seal the
defendant
entire day?
related to a number of pieces of testimony, documents, audio recordings, video
Rude.
recordings, other pieces of evidence. The admissibility of those things is as yet undetermined.
In every case, Your Honor, motions in limine are public. It is not that big of a deal.
And the court is persuaded by counsel's stipulation that to ensure the integrity of voir dire and the jury pool, and in recognition of the fact that potential jurors have already filled out their questionnaire, and so there would be a reduced ability
There is court tomorrow.
the day after to investigate
I just think we're not invited.
whether they're exposed to information regarding
I feel like I've been uninvited to a dinner party. But wait, y'all are getting together without us. All of a sudden, the court's like, you can't sit here.
inadmissible evidence. The court finds that it is necessary to close tomorrow's hearing
I hate
to
this.
the public
We didn't do anything
to
wrong.
Seal the audio recording of it so that it is available only to counsel, but not to the public at large. The court's ruling regarding what is admissible and what is not will be part of the public record.
Why do you hate us? Well, the end of the day in the Richins case, we will not be back together in this case. Tomorrow, we will be clearly doing something else because the judge has sealed the entirety of the day tomorrow, except for the court's rulings, which we will probably have and go over next week. The motions in limine have largely been sealed as they were filed, and now argument on the motions in limine are going to be sealed. I don't think they have to be. Also, if it's in the moving papers with specificity, the logistics of we don't think they've laid foundation yet, okay, well, that'll come in with this witness. That's not really specific. You don't need to get in to the nuts and bolts of a case. But the court said that today wouldn't be streamed and then change their mind. I don't think they're going to change their mind on this one, though. So at the end of the day, the court has largely denied the defense motions to keep out the prosecution experts. But it is unclear if we will see those experts at trial because the prosecution may choose not to call them. It really is fact dependent. One of the experts is rebuttal only. One of the experts is like half. And that expert, the handwriting expert, Mr. Throckmorton, will be coming in the case in chief and then perhaps testifying in rebuttal. And then the third expert on intimate partner violence may testify if the foundation is laid for what knowledge the victim may have had. And that's just going to depend on the witnesses as it comes in during trial. So we are, well, annoyed. I'm annoyed, Your Honor. I'm very frustrated. It's like you all get to come to the party. Just kidding. Fuck you. I know the court is doing what they believe is best to protect this case, but open courts are open courts and require openness. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.